Good evening, everyone, and welcome to our Ramaz Alumni in Conversation, an evening with 7 of the 9 Ramaz alumni who have clerked over the years for Supreme Court justices. It is an absolute privilege to have these very illustrious alumni with us this evening and to have all of you here as well. We begin tonight, as we do all of our Zooms, by first and foremost wishing all those who are ill, family members, community members, greater community members, or anyone that is suffering with an illness, whether corona or others, wishing them a refuah shlema, a full and speedy recovery. Our thoughts are with each and every one of you. And we wish those who have lost loved ones during this very difficult time period comfort, and our community stands together with you and are here in any way to be supportive of you. These Zoom programs that we have each evening or a few times during the week are here to give opportunity for us to reintroduce, in many moments, members of the community who are doing various things that make us very proud and make us realize how lucky we are, how privileged we are to be the kind of community that we are. And what better way to have an evening for a Zoom program than to find 7 of our 9 alumni who have done work that we truly believe in as a democratic institution and living in the country that we're privileged to live in as American citizens, and 7 people who have clerked for Supreme Court justices and have made us so proud in the work that they do each and every day. They will be moderated by our very own Dr. John Jucovy, the Director of Humanities at the Ramaz Upper School. Dr. Jucovy has served as a role model and an example for all of us, and almost all of the people that are on today's Zoom have had him as a teacher and a mentor. I'll introduce them briefly and then hand the program over to Dr. Jucovy. We begin with Sherry Colb, the class of '84. She is currently the C.S. Wong Professor of Law at Cornell Law School. Prior to teaching at Cornell, Sherry was a member of the Rutgers University Law faculty, and she also held the position of visiting professor at the University of Pennsylvania and at Columbia Law School. She clerked for Justice Harry A. Blackmun. Rebecca Deutsch, class of '94, currently the Assistant General Counsel for Law and Policy at Consumer Financial Protection Bureau. She spent 4 years as an associate WilmerHale, attended Yale for both undergrad and then law school, and served as the clerk for Justice Ruth Bader Ginsburg. Michael Gerber, class of '97. Currently, he is an assistant U.S. attorney and co-chief of the Violent and Organized Crime Unit in the United States Attorney's Office for the Southern District of New York. He previously served as the co-chief of the Narcotics Unit and as co-lead task force attorney for the Organized Crime Drug Enforcement Task Force. Prior to joining the U.S. Attorney's Office, Michael was an associate at Wachtell, Lipton, Rosen, and Katz. He received his JD from the Yale Law School in 2005 and his bachelor's from Harvard in 2002. He was a law clerk for the Associate Justice David H. Souter. He's also a Ramaz parent today of wonderful, wonderful Ramaz students. That's his real claim to fame in many ways. Ben Gruenstein, class of '92. Ben currently serves as the litigation hiring partner and is member of Cravath's Investigations and Regulatory Enforcement Practice. He also participates in the firm related to blockchain and financial technology. Prior to joining Cravath, Mr. Gruenstein served as an assistant U.S. attorney in the criminal division of the U.S. Attorney's Office for the Southern District of New York. He received his A.B. summa cum laude in philosophy and mathematics from Harvard, and then in 1996, that was in 1996, and then a JD magna cum laude from Harvard Law School in 1999. He clerked for Associate Justice David H. Souter. Dan Meron. Dan was the class of '83. He is a partner and co-chair of the Latham and Watkins Healthcare Services and Providers Industry Group. Dan joined Latham from the United States Department of Health and Human Services, where he served as their general counsel. Prior to working at HHS, Daniel was the Principal Deputy Assistant Attorney General for the Civil Division of the U.S. Department of Justice. He attended Harvard for undergrad and then for law school as well. He served as an associate, as a clerk, for Justice Anthony M. Kennedy. Danielle Sassoon, class of 2004. She is currently the Assistant U.S. Attorney for the Southern District of New York, where she serves as a Deputy Chief of the Appellate Division and was formerly a member of the Violent and Organized Crime Unit. She works very closely with Michael Gerber. Before joining SDNY, she was a litigation attorney at Kirkland and Ellis LLP. She also served as an adjunct professor at NYU Law School, where she taught a Supreme Court seminar. Danielle received her JD from Yale Law School and her BA in History and Literature, magna cum laude, from Harvard College. She served as a law clerk for Justice Antonia Scalia. And finally, our very own Gil Seinfeld, class of 92, currently the Robert A. Sullivan Professor of Law and Associate Dean for Academic Programming at the University of Michigan Law School. He teaches and writes about federal jurisdiction, the constitutional law of federalism, and civil procedure. Prior to joining the faculty of the University of Michigan Law School, he was an associate at the law firm of Wilmer, Cutler, Pickering, Hale, and Dorr, where he focused on appellate litigation. He holds an AB in government from Harvard College and earned his JD magna cum laude from Harvard Law School, where he was the managing editor of the Harvard Law Review. He was a fellow in the program in law and public affairs at Princeton University as well. He served as a law clerk for Justice Antonia Scalia of the US Supreme Court. And so I introduce this panel, and who better to moderate it than our own very wonderful and dear Dr. John Jucovy. Thank you all for giving us the honor this evening for being on with us. Dr. Jucovy.
Welcome to our guests and welcome to our attendees who are watching this. I see so many names that are familiar and some unfamiliar ones and some identified only by your phone number. I want to urge all of you, I think the way it works, the way we have it set up, is that you could post something in the chat that will be seen by the moderators and panelists, and I can then at opportune times direct some questions to them. But let's begin. Welcome all. It's great to see everyone here and to be back in touch. I'm going to start with a reminiscence that when I first heard, Sherry, of you becoming a clerk, I was so excited and proud. I thought, wow, it's really cool that I know somebody who has achieved such a position of prestige and prominence. And then I heard about Dan. And I heard, I'm not going to necessarily go in order, and I'm not going to repeat all your names, about Ben and Rebecca and so on and so forth. And I began to think, this is a little bit odd. The Ramaz school seems to have, I know that there used to be called a Jewish seat or the woman's seat on the court. Maybe there's a Ramaz position or positions as clerks. So I want to start with this. Is there something about not just your, and I'm talking about both of these things, your Jewish background, your Jewish upbringing, but your educational experience, whether it was 4 years or 13 years or whatever at Ramaz, which may have contributed to your career paths and also your decision to, after all, go into, at least for some years, public service and serve as clerks on the Supreme Court. So we're going to do this in the fairest, or maybe it's not the fairest possible way, but I'm going to go in what I perceive to be alphabetical order and start with you, which is also chronological in this case for clerkships. Sherry.
Yeah, I just was trying to remember the alphabet.
Yeah.
Yeah, I do think so. I mean, it's hard to draw a direct causal line, but I think that at Ramaz more so than at other yeshivas, there's a sort of welcoming of different points of view. And so, you know, there's always, whenever there's a Hillel, there's a Shammai, and there's, you know, there's always somebody to disagree. And so when I came to law school, it was very familiar to me to have that the law is, I think a lot of people think, oh, well, you want to know the law, you look it up in a book. And I think now probably there's a greater cynicism about what the law means in view of recent events. But I was familiar with the idea that people could take different positions on things. And clerking, at least for me, for Justice Blackmun, was very much a job involving writing dissents. And so writing dissents was really just saying, yeah, well, I don't agree with that, and here's why. And so you're not just the guy screaming at Times Square, you're writing a dissent for a justice, but it's kind of similar. And that was kind of an activity that was encouraged. We had Yemei Iyun, and we would, you know, talk about different sides of an issue. And so, you know, that was a comfortable place to be. I mean, it's, you know, in Talmud and everything, it's always about people disagreeing in the adversary system. And I think that's very much part of the education.
It still is. Rebecca, I hope that volume is working. Can you answer that question? Are you able to, can we hear you? Oops, it's not working. Leah, you want to work on that with her? We're not hearing you. So while we get your volume working, Michael Gerber, you want to answer that question? Your upbringing and Ramaz. I know you spent many years at Ramaz.
Many years. And maybe this is sort of picking up where Sherry left off. You know, I think one thing in my experience, sort of a hallmark of Ramaz education is asking a lot of questions and questioning authority at times. I mean, doing that with respect, doing that not out of ignorance, but, you know, out of engagement, and not being afraid to ask tough questions. I think that's something that Ramaz teaches and encourages its students to do. I think Dr. Jucovy in particular does a great job at teaching students to ask, you know, good, tough questions, and to push back sometimes on, you know, what is the accepted wisdom, the conventional wisdom, what someone in authority is saying. You know, if you think about clerkships generally, and then in particular about a Supreme Court clerkship, step back and think about it for a second. You know, you have people who are just, you know, one or a few years out of law school, knowing very little about law or about life maybe, and working with a clerkship, you know, and just do any clerkship, in particular in a Supreme Court clerkship, working with a Supreme Court justice. And part of a clerkship is asking questions, and I think you know, talking issues through with the justice, respectfully asking justice questions, pushing the justice in terms of what the justice is thinking, or how the justice is thinking about it, and to not be afraid to do that, to be prepared with modesty, with humility, but also with that quality, like I said, of being prepared to say, even though someone has a lot more experience than me, knows a lot more, but I'm still going to ask the questions and push. And I think that's something that I learned from Ramaz, and I think is important for lawyers generally, and then particularly valuable for clerking.
I'll remind you that among the authorities whom you stood up to was myself. When
I know.
When you were a 10th grader, you never stopped giving me trouble about my attempt to convince you that Marx was secular Judaism writ large. Do you remember that?
Yeah, no, I still think you're wrong.
I think you may have convinced me. Rebecca, do we have something working there?
Can you hear me now?
Yes, good.
Oh, good. I think for me, for a long time, I always attributed sort of my love of the law to Talmud and sort of the legal process of thinking and hearing different sides of an issue and different perspectives. think recently I started thinking that it was almost as much the textual exegesis we did in Tanakh and Bible that sort of really hones you into looking at one word and analyzing it and reading all different commentaries on what it can mean, and realize that that's a really unique way of thinking, that other people don't do that as much, like even in literature, the way you would with a text that's with the Bible. And of course, I think what we learned in history and English about writing and being clear and organized and having a strong thesis statement were things that definitely served us all very well.
The history paper is toughened up.
Those history papers.
Yeah. Ben.
So let me just step back for a second. For those who aren't familiar with Supreme Court clerkships, it is a job that people typically do out of law school after having a first clerkship and then get hired to do a second clerkship. And it's a job that we were all very lucky to have. I think luck plays a major role in it. But also you have to do very well in law school, which requires kind of an obsessive interest in the law, which I do think studying Talmud twice a day for however many years does give you a good preparation for that and a good background. I also would attribute it in part to Ms. Gorfinkel's senior math class, where we learned how to prove theorems in a very orderly way. And I should say that I don't think it's really a coincidence that we all ended up clerking. Michael and I clerked for Justice Souter, who is far from Jewish, but I don't know if he would agree with me that he has a Jewish soul. And every year he would have a Shomer Shabbos clerk who he referred to as a Saturday Sabbatarian. So at least as far as he was concerned, there's something I think that he saw in all of our backgrounds that was compelling to him when he did his hiring.
Thank you. Dan Meron.
Yeah, thank you, Dr. Jucovy. So a lot of people have hit on some of the things I would have mentioned, but I think it's two things. First of all, before even Ramaz, it's so part of being a Jew in the United States, a non-assimilated one. I think we all at some level grapple at some point in our lives with the sort of the tensions between the imperative of democracy and the majority will, and what the majority likes, and at a very personal level, the importance of preserving space and liberty for the minority, and how that you struggle and reconcile that is something that it's really hard to be have an identity as a Jew and not think about at some kind of deep level at some point in your life. And I think that is something that Ben said, passion for the law, a passion for the constitutional law in particular, and some of the areas that in particular come up at the Supreme Court. And then in a sense, these aren't really parallel poles, but the Ramaz education, which married, a real sophisticated, high-level study of history and of politics at the really college level. Once you get to the APs, both of American history, politics, and European history, which gives you another perspective on some of the fundamental issues and how other countries grappled with it. And then marrying that with, and other people have mentioned this, but the Talmud and learning how it really teaches you, a lot of about legal reasoning. And I would point out that if you think today about a lot of the debates that animate people in the law about how to interpret laws generally, the Constitution particularly, textualism versus thinking about the purposes of the prohibition, which one should take precedence when you are trying to interpret a particular rule of Torah, bright line rules, the advantages and importance of bright line rules that people can follow versus flexibility to particular circumstances. The risks of violation if you make the rule kind of too clear versus, too gray versus clarity. A lot of these issues are issues that the Supreme Court and the law generally grapples with to this day, really the same way. And we got exposed to it at a very young age. So, I think if you look at why there's 9 clerks from a very small school in New York who clerked, I think there's something to that. And people have remarked that if you look at the current Supreme Court, it's kind of interesting in a country that's majority Protestant. There's not one Protestant on the Supreme Court. They're all either Jewish or Catholic, and obviously we come at this from a Jewish perspective, but Catholic learning has some elements also of studies of the law. There's one justice, to be clear, who's currently practicing it as a Protestant but was raised Catholic. So I feel I'm entitled to make that generalization, but some perspective.
Thank you. Danielle.
Yes, so I agree with what everyone said, so I'll share a story, which is that when I interviewed for the clerkship with Justice Scalia, among the things he asked me was, what prepared you to do well in law school? What sparked your interest in the law? And what came to mind and what I said was, in high school, I studied Talmud for hours every day. And that process of engaging in really what's a form of the Socratic method, which is how they teach law school, and also spending days unpacking the meaning of a single word or a single line, prepared me for analyzing the law in a similar way and in a vein that was very appealing to Justice Scalia, because core to his judicial philosophy and interpretive methods was textualism, which was really plumbing the meaning of single words or sentences and really digging into the text. And so that resonated with him. And he told me that when he was a student at Harvard Law School, the students who out of the gate were the most impressive and most prepared were the Orthodox Jews who were prepared for that back and forth Socratic method and who found it intuitive based on their religious studies.
Great, great. And Gil.
Hi. So first, I want to echo something that Ben said. He described Justice Souter as having certain values that seem to have led him to choose a large number of clerks, that were Shomer Shabbat, that sort of thing. I think that there's something to that for Justice Scalia too, for whom I clerked. There's not only Danielle and me. I know of at least 2 other clerks that he had during maybe a 10-year period of time that all grew up in Orthodox traditions. In my case, I actually think my 3 co-clerks were all quite from Christians. But there was something like, I think Justice Scalia and we connected over the fact that we were both hot-headed ethnics from New York. And that seemed to create some basis for connection between the 2 of us. So everybody has said many of the things that I would have said already, certainly about engaging with Torah, with Talmud, textual study. So I'll just add one thing to the mix that I thought a lot about during both of the years that I clerked. And Ramaz is certainly a big part of this sense of myself. It's really rooted in my Jewish identity. It comes from my parents. It comes from the education I had before Ramaz and from the time I spent in Israel afterwards. And it was just a sense of responsibility for marginalized people, like something that I think comes to us both from our sacred texts, like certainly from the Torah, directives about how you treat a stranger, how you treat a foreigner, how you treat the poor, that sort of thing. And then by virtue of our history and a history of millennia of persecution, simply by virtue of who we are. And so like that certainly, when questions of that sort come up in the law all the time, where the question of how people are going to be treated, how vulnerable people will be treated, and how people will be treated by the law, what limits the law places on treatment of one another by virtue of their status, by virtue of their identity. And I certainly think I grew up, my Jewish tradition, it taught me that I have a certain responsibility to kind of look out for the people, or at least be sensitive. The law doesn't always permit you to do what you want to do, but to be sensitive to the particular ways in which the law affects marginalized people. And so that's something I took from my time at Ramaz that affected me as a clerk, as a lawyer, as a law professor.
Thank you. In your responses, the sum total of your responses brought up many of the issues which I'd like to pursue for the time that remains. What I'm going to begin with, though, happens to concern the prestige and legitimacy of the court. Apocryphally, I think I'm getting this right as a historian, Andrew Jackson is supposed to have remarked, I think he really didn't. Justice Marshall has ruled, now let him enforce it. The crux of that is that ultimately the court's power to shape our institutions, our laws, politics, rests upon the willingness of people in other branches, everyday citizens, to respect the authority and prestige of the court. And central to that, according to many historians of the Supreme Court and of the American judicial system, is the belief that the court is not a political institution, that it renders judgment based upon not an objective, but a reading of the Constitution, an interpretation of the Constitution, but not a politically motivated one. So that's a long introduction to this. At the present moment, my sense is that that reputation is something which has been undermined and threatened. And I wonder if any of you care to comment on what you think is the future of the court in terms of its legitimacy and prestige. What I'm not talking about here is I want to make this clear, the rightness or wrongness of any particular policy pursued by the executive branch or the Senate. What I'm talking about is perceptions in the eyes of the American public. So does anybody care to jump in, or should I just randomly call on someone? How do you see the present state of the court in terms of prestige and legitimacy?
Well, I can start and say that I don't think that what's going on now is necessarily new. I think the concern about the role of the court has been there for as long as we've been alive. I mean, since Roe v. Wade in 1973, and then, fast forward to Bush v. Gore. And now today, there have always been concerns about the legitimacy of the court and whether it was more of a political institution than a judicial institution. I think for what we're seeing today, some of the history over the last 4 years is certainly a concern about the interplay between the executive branch and the judicial branch, and a concern about whether the executive branch would respect the judicial branch. I think that's something that's new, but ultimately, I think the reality is that the justices on the Supreme Court very much understand their role and very much respect the institution of the court, more so than having any desire for any particular political outcome.
I'm going to pursue that with you for a moment, Ben. Do you think, and my understanding is you're saying you don't feel that in terms of public attitudes and public perception, regardless of how the judges reach judgment, you don't feel that the public itself is more prone to view the court as a political partisan institution?
I mean, not more so than any time in the last 50 years, I don't think.
Okay. By the way, just to add in, when I was growing up, it was impeach Warren over the Brown v. Topeka decision. So there's truth to what you say. Anyone else have a comment on that?
I have a thought.
Go ahead, Sherry.
So I would say that something is a little bit different now from some of these other periods that you're describing, which is the controversies over Roe versus Wade and over Brown v. Board were controversies about the substance and the interpretation of the Constitution, and of course the underlying policies, because if you scratch a little beneath the surface, that is typically what is driving the interpretive approaches. And what's happened this time is that you have I think what we've had is, I guess I'm protected with tenure, so I can say what I really think about this. And I think what we've seen is a kind of aggression-based selection of justices. And so it's not the decisions they're making, although I am certain that those decisions will reflect exactly what they're meant to reflect, but the very selection of them. And I think in some ways, the most troubling of all was the Kavanaugh scene, because you had someone who's chosen, and until the information came out, it seemed like he was he's a pretty reasonable choice given who was making the choice and selection and so on. And then this, material comes out about him during a period when people are beginning, allegedly, to take sexual violence seriously. And we have the president actually mimicking the professor who gave testimony about him. And we have a president who doesn't say to put in Amy Coney Barrett at that point, which was what some people had proposed he do. And this isn't, to say about, like, if Kavanaugh had said, okay, when I was 18, I was blackout drunk all the time, so I don't know whether I assaulted a person, which to me would have been the truth. Can you forgive me? And then say, he's in his 50s now. All right, let's forgive him. But instead, it was a very different kind of like yelling and banging on the table and acting sort of part of Cro-Magnon. And I think that whole display was discrediting for the institution. I suspect that the justices on the court found it off-putting, much in the way they did the behavior of Clarence Thomas for far less egregious behavior. So there was the kind of revisiting, and there had been, and I'll just say one more thing about this, there had been an interview with Anita Hill that was, I don't know, like a month or 2 months before all of that. And she was asked, do you think the same thing would happen today that happened at that time? And she said, no, I think things have changed. I don't think that the same thing would happen. So I think that there was something very disillusioning and dispiriting about what took place. And that's not to take away from Justice Kavanaugh as a justice. He is, everything that, the right wing wanted and more, and he's very intelligent and so on. But that process by which, a professor who very bravely came forward to talk about something quite credibly, only to be met by banging on the table and here's my wife and I'm fantastic. I think that sticks around a little bit. At some point people forget and then, we're back to normal. But that was, I think, a really low moment. And it was one that resonated with an old low moment that many people had hoped was behind us.
So before we hear from others, I'm going to make an observation, which is, it's very interesting as a historian, because in this case, the court itself is in effect being rendered a hostage to processes that are taking place outside its own judicial decision-making from what you're describing, but not actually by its own decisions. Is there any further comment? Yeah, go ahead, Danielle.
I think it's not just the processes, but also the coverage. I think, I'm sure people feel this way when there's news coverage of their particular professional fields, but going back to the time I was clerking, there was definitely daylight between how the court was covered in the media or what the focus was in the media or kind of the messaging the public was getting, and then the nuance you see when you're inside the court. And just to be a little more specific about that, the year I clerked, the court decided some very high profile cases that were seen as political. The Voting Rights Act, part of it was struck down. DOMA was decided. But at the same time that year, when I was working for Justice Scalia, he actually diverged quite often from his conservative colleagues, both in terms of outcome, often on criminal procedure, administrative law, criminal law, So both in terms of outcome, but also in terms of methodology. So the commentary can sometimes reduce the court to the right wing, the left wing, but in fact, there was really a lot of variety, even when you looked among the conservative justices in terms of how they interpreted the Constitution, style, tone, particular philosophy about certain areas of constitutional law. And I think that's lost in some of these discussions.
So Ben, I'm just turning back to you to make this comment. There are many people who feel that what's happened in terms of American media and American news coverage, the 24-hour cycle, the proliferation of almost boutiques sources, that has changed to some extent the way the public both receives and responds to and is shaped by the news, and in this particular case, the court. Certainly it has received, like so many other things, more prominent bird's eye view of everything that's going on. Any further comments on this issue? Go ahead, please, Gail.
Yeah. One thing I would observe actually is that I think that if there are changes that are taking place in terms of broadly held perceptions of the Supreme Court or of courts in general, it's important to put them in the context of people's attitudes towards all other kinds of institutions as well, right? So public attitudes and trust in and confidence in government, in approval ratings for Congress. You know, I feel like every 3 years they tell me that they're at a new all-time low, and there's just so much tumult and division relating certainly to the presidency and to elections generally right now. So I think it's important to understand if people's attitudes and orientation toward courts and to the Supreme Court are changing, if they're becoming more cynical, it's happening alongside a series of parallel changes that are relevant to other branches of government and to government in general. So I'm not sure that there's something distinctive that's happening to the court. And I actually think in the grand scheme of things, most people think about courts very, very little and have very little by way of an opinion of the courts, and they certainly don't have an informed opinion about it. So a lot of what's happening here is, as always, being filtered through the media. This relates to what Danielle was saying. And so there's like talking about changing public attitudes toward the courts, like that's a concept that itself requires some unpacking. Like what exactly are we talking about? Because, you know, the vast majority of Americans, I don't think, would purport to have a meaningfully informed opinion about the Supreme Court, the courts, who the justices on the courts are, you know, on the court, and so on.
And Dan.
Yeah, I think there's, building on some of what was said before, I think, first of all, there is a cynicism generally, but I think the polls will show even today that by far the most respected of the three branches is the Supreme Court. So, you know, that has been true for a long time. It remains true today. You know, I do think that the whole news cycle, it lends itself to simplifying issues in a way that makes it sound like things are coming down to political and the Republican versus Democrat meaning of the terms. And I just do not think that is how the Supreme Court justices decide cases. I think there's all kinds of examples that one can point to. That doesn't mean that they don't come to it with certain well thought out and in some cases fairly ingrained judicial philosophies that one can that exist and that might you know, be used by people who understand them to predict how they might vote in a particular case. But that's not because they're thinking about this as R versus D. I just don't. I really don't think so. And the problem is, I do think the biggest risk actually to the legitimacy of the Supreme Court is some of the political debates where people, you know, to try to get up votes on both sides. Everyone's guilty of this. I think try to simplify and characterize. I mean, this notion that we had recently that depending on whether you know Coney Barrett would or would not be confirmed, that somehow she was going to approach the Affordable Care Act as a, you know, that's an Obama piece of legislation as opposed to a Trump piece of legislation. I think people who understood the legal issues that were actually before the court in that case, you know, which ultimately is severability analysis particularly, I think, you know, I wouldn't be surprised if that comes out unanimously. So we'll see what they actually end up doing, but I think that I do think there's a danger of delegitimizing the court, or at least tearing it down a little bit if you simplify to the point of really almost demagoguery how in explaining to people how they rule. But I do think that at the end of the day, the Trump administration has lost many cases before a conservative court, and the history of this country is replete with presidents who've appointed Supreme Court justices only to be very disappointed with how they ended up ruling. So we'll see. I think from a long-term perspective, I still am sanguine about the strength of the court.
Earl Warren being yet again one of the more famous disappointments, supposedly, to Dwight D. Eisenhower.
Well, I'm sure Souter disappointed President Bush. I mean, you could go
right.
Stevens, President Ford. I mean, you could just go on and on. There's so many examples.
Yeah. Michael and Rebecca, we haven't heard from you. Is there something that you wanted to add to this part of the discussion?
Add to what Sherry said about, there is something about the confirmation process, and I would point to the differences in the way that Justice Scalia's seat was filled and Justice Ginsburg's seat was filled, as I think really drawing the public's attention in a different way to the legitimacy of the court, because it's not the decisions themselves necessarily that they're questioning, but the process by which the justices were picked that seems politicized. And I have no firsthand knowledge, but I think the justices, particularly the Chief Justice, is aware of that. And I would guess that there would be some, if the court wants to maintain its legitimacy, might be more careful in granting cert on very controversial issues in the next term.
That's
that's my hope.
Yeah, that's going to bring us to the next subject. But Michael, this is something that you wanted to
add. Just one point. That is that, and this is not new. So maybe has been sort of the beginning of the conversation. You know, I'm not sure any of this is new at all. But you know, you have this phenomenon, I think, year after year now, where every term you have a handful of cases that are high profile, that touch on politically charged issues, and that's what gets coverage. And it's just, you know, one thing you see, particularly as a clerk on the court, is that, you know, most cases are obscure, often really obscure, right? Questions of administrative law, statutory construction, and obviously there can be a significant divergence in terms of different justices' interpretive methods, but there is this sort of massive disconnect between the way that you have the media coverage or public perception, which is shaped by a very, very small percentage of the court's docket. When most of the work, most of the opinions involve issues that don't get really coverage at all. They can be quite significant, of course. They can have very significant impact, but in ways that don't really play into sort of the Democrat-Republican divide, as Dan was saying, where the outcomes don't have an obvious political valence. And again, it's not new, but there's just this real gap between the day-to-day work of the court and then the very small number of cases that actually get public attention.
Thank you. Dan and Rebecca, you and in effect, really all of you touched upon whether the court makes decisions, which it seems to be the consensus that it's not because they're engaging in politics. Every decision ultimately is politics. It impacts politics. It impacts society. And Rebecca, you in effect made a cautionary note about your hopes. One of the most important powers that the court possesses is, of course, the choice they make in what kinds of cases to have, aside from the actual decisions that they render. And among historians, students who've done papers on the court packing issue back in the 1930s will remember that they learned about the two chief historical interpretations. Does the court render decisions because of external pressures to a larger extent, or is it doing it on the basis of a way of interpreting the law, externalism versus internalism? I wonder if any of you could give us some insights from your own experiences about how cases are chosen, to what extent they're being chosen because something seems to be constitutionally interesting, or because perhaps there might even be a political moment that it's important to settle some question. I'm remembering, of course, one of the most famous cases in history was the choice of taking the Dred Scott case because they wanted to settle the issue of slavery and federal powers. That was ultimately a decision that backfired for them to take that case. So how from your experience, can you tell us about anything that you recall where maybe an attention to the wider social environment played a role, or not? Is the externalist argument more persuasive, or the internalist argument? Let's yeah, go ahead.
I'll jump in because I was there most recently, and at least now there's a fixed kind of set of guidance on how cases are decided. So for starters, what some people might not know is that one of the big roles of the law clerk is actually to sift through the petitions to the court to grant cert in a particular case, to hear a particular appeal. And the court gets roughly, I think, 7,000 or 8,000 of these petitions a year, and grants an increasingly small number of those cases, around 70 to 80 cases a year. So a very small fraction. And the clerks are the first line of defense on these cert petitions. They get divided among the clerks across the court. And each week, every clerk has to write a certain number of memos that goes to all of the justices, explaining what the issue is on appeal and giving a recommendation about whether it's a case that the court should grant or not. And there are particular criteria that guide that advice. And the main one is whether there is a divide among lower courts about the issue. So one of the main functions of the Supreme Court is resolving a legal question where multiple lower courts have weighed in and come out differently on the issue. So that's area number one. And then issues of national importance are also an area where the court looks to grant cert. And I would say it's not necessarily because the court is looking to insert itself into a political issue, but because logically, if the court doesn't grant a case on a major piece of legislation, for example, what that means is that a court of appeals decision in one particular jurisdiction is going to be the last word on the matter, and instead be the court to decide it. So it's not as though if the court doesn't intervene, then nobody's going to intervene. You're often going to have a decision on the books that will resolve the case, sometimes for a large part of the country, without the court's intervention. And clerks are actually very, very cautious about recommending cert because it's much less problematic as a clerk if you've recommended denying a case and the court never hears it, versus recommending they grant it. Then the court hears the case and realizes there's some issue with this particular record or this particular set of facts or the particular.
I messed that up once.
Sorry?
Danielle, I messed that up once. Like
it's
so much
really
worse.
shameful.
It's so much worse to have a false positive than a false negative, and
Exactly.
I had a false positive. But fortunately, my clerkship was over. They didn't hear the case until the next year, so I wasn't there for the big mess.
And at least my year, the Scalia clerks were very forward-leaning. We prided ourselves on being brave enough to recommend that the justices grant a case, whereas others had more the reputation of being very gun-shy. But so that criteria tends to guide the recommendation process. And so I would say it's more technical than anything else. But Michael.
So a couple of things before you speak. First of all, Gil, are you able to tell us what the case was?
I mean, I don't even remember the name of the case. I just remember that I can tell you one thing that I remembered about it, actually. This is a somewhat interesting story. The court gets hundreds and hundreds of petitions each year that are what we call handwritten IFPs, informa pauperis, someone who's proceeding and can't pay the filing fee. And invariably, huge swaths of these are written by prison inmates who, I don't mean to be dismissive, but like in some cases, you'd say they have nothing better to do than write 7,000 petitions to the Supreme Court. So, as you can imagine, when you're dealing with so much work that has so much gravity about it, and so many of the people who are writing them have no legal training, the probability that you're going to find a a legal issue that really matters in a handwritten IFP hovers close to zero, and anxieties about the quality of the advocacy or your ability to, I mean, obviously the petitioner, the prisoner is not going to advocate on his or her own behalf at the court, but just what you're reading in the papers, you know, as they come in, you might feel real uncertainty as to whether you've really wrapped your brain around the case. In any event, I had one of these and I read it and I was like, I think this guy has an issue, actually. And so it goes through multiple stages. We had to call for a response from the state. And, you know, long story short, the court ended up granting certiorari, which in theory and when it happens in practice, there is something wonderful about the fact that a prison inmate can petition the Supreme Court of the United States that gets 8,000 petitions each year and only hears 80 cases and ultimately get an audience before the Supreme Court. As it turns out, there was a jurisdictional problem that I did not surface and that no one else caught along the way. And so the next year when the case came up, really in the course of the substantive briefing on the case, the depth of this jurisdictional problem became more and more apparent. And I think the justices had to dismiss the case as improvidently granted. And Justice Scalia actually gave me a hard time when I wrote the Poole memo, because I went to tell him, Justice, I just want you to know I'm going to recommend the court grant in this case with a handwritten IFP, and you should know your clerk's name is going to be on the, you know, just that I'm going to be the guy who wrote it. And he said to me at the time, he's like, there's going to be a problem, it's going to be a mess, and you, Seinfeld, are not going to be here when, you know, when things hit the fan. And it turns out he was right. So anyway, yeah, I've made that mistake. False positive, not so good.
Good job. And Gil snuck in the full term for what assert stands for. Do you want to just repeat that?
For what? Cert is short for certiorari. You're filing a petition for a writ of certiorari. It's I guess God, it's an old Latin term.
I guess so. Danielle, I just want to pursue one last thing. In the case where the court is taking a case, granting a cert because of a case of national importance that a lower court has ruled on, does that in any way signal a disagreement with the lower court decision?
That's a good question. I think it's case specific. For example, healthcare, the Supreme Court just wasn't going to let the DC Circuit have the last word on whether healthcare was constitutional or not. And while on the one hand, just wading into these issues can, like you said, seem political or undermine the legitimacy of the court. On the other hand, I think the country does want the Supreme Court to be the final word as opposed to a court of appeals on questions like that. But typically, where there's a split, the particular case that's granted doesn't necessarily signal that it's going to be, that the court is going to be reversing what the lower court did.
Right, thank you. Michael.
Yeah, just one point following up on what Danielle's been talking about. You know, these cert memos that clerks write. I think I'm not sure which justices exactly are in the cert pool these days and which are not. Historically, certainly most of them have been in the cert pool. And what that means, right, is that you're a clerk, you're writing that cert memo, either recommending grant or deny. That's going to go to most of the justices, whoever's in the pool. So you're not writing that memo just for your justice, right? You're writing it for lots of justices, and justices of different stripes, right? Different perspectives on things, different interpretive approaches. And so to Danielle's point, you know, there's something actually, I think, it's something very healthy about that in a way that when you're writing these memos, by their very nature, you're writing for the cert pool, they're not tailored to a particular, a narrow sort of audience in terms of the justice's approach. You're by definition writing it, you know, for a broader range of perspectives, and that's going to push you to focus on, okay, just, you know, laying it out, sort of just telling it straight. Here's a split, if there is a split, and here's sort of how it plays out, or here's why there isn't a split. And then you will have some justices, and I'm not sure that the present state of affairs, you will have some justices who are not part of the cert pool, and they will have their clerks do it all themselves, right? So they have their clerks just write for them. I think they'll take a different form because you have many fewer clerks for just as many cert petitions. But that's a different approach. Then you have a justice saying, okay, you're my clerks, you know, I want you to write these memos, write them for me.
Yeah, Justice Stevens did that.
You're sort of catering to that. So sort of two different approaches the justice can take.
Yeah, Justice Stevens had his clerks read all of the petitions, just the 4 of them. And Justice Blackmun had us initial which clerk wrote, whom they clerked for at the Court of Appeals level and whom they're clerking for at the moment. And based on who was in there, he would take a close look at the pool memo and then he would say, let me see the papers. So there wasn't, I mean, I think in general, basically there was a presumption of denial, which I think it's true that you're much less likely to get into trouble by making that mistake, saying deny and really it should have been granted. But to the extent that there was scrutiny, there was some scrutiny based on the politics. And, you'd have Justice Blackmun would be like, okay, Judge Luttig, this person clerked for Judge Luttig. I would like to see the papers. I'm not satisfied with the memo. And because there was a sense of potential distortion that was expected. So there were, and it wasn't just going in one direction. I mean, I knew that because I was in that chambers, but there were, Laura Ingram, just to give you an example, clerked for Justice Thomas when I clerked for Justice Blackmun. I know some people are probably thinking, oh, I didn't know she was a lawyer. But anyway, what?
I didn't know she was a lawyer.
Yeah, now you know. And, it was a political situation. I agree that people have even more contempt for the other branches. So to that extent, if you're grading on a curve, you're getting the benefit of not being Congress or certainly at the moment the president. But, I think that the amount of respect people would be like, hey, I don't understand. How is it that a rapist gets to be on the Supreme Court? Like that is a really problematic thing that people didn't used to have to ask. So just to throw in my cynicism a little bit.
I would just add, I think it is true that there's, formal criteria and the vast majority of cases aren't political in deciding which ones are granted. But I would say on the controversial cases, it's not surprising that some of the votes in terms of granting cert also divide, 5-4. And I think that shows that maybe the justices in the minority don't want the case to be heard at that time or the issue revisited, because you do see divides among the justices on those issues that might align with how they divide on the substance of those cases.
And among the divides, and it's really almost like the great American pastime, the new national pastime is we all love to interpret the Constitution and come to our own reasonings about what the court's going to decide. And of course, the different forms and modes of interpretation are, at least to a small degree, known by many people in the American population. One of our members of the audience, Alex Rabinowitz, I'm going to mention your name, who is heading to law school shortly, is asking the following about interpretation. Would you agree with Justice Kagan that we're all textualists now? And of course, that's going to, when you answer, you're first going to have to explain what a textualist is. So who wants to take the challenge? Are we all textualists? Should I call on this? Yeah, go ahead. I was going to call on the Scalia clerks.
Right. Well,
I was going to say a Scalia clerk has to answer that. But.
Yeah.
No, actually, so
Dan, take it away.
Well, yes, I'll prevent you from the awkward position of having to praise your justice because I will not have that bias necessarily. I think that is one of the big legacies of Justice Scalia, is that whether or not the ultimate decision follows the simple text or textualism, what the majority decides, every justice today, when you write an opinion, they start by quoting and grappling with the text. And you'd think that would be kind of an obvious thing, But when you look at opinions from the 60s and 70s, that was often not the case. And I think that, you know, to some extent, Justice Kagan is exactly correct that at least not necessarily that it's ultimately the determinative factor, but that it is now, I think, acknowledged by all of it, an important and very important factor and a starting point for interpretation is the text, which I think is really probably the greatest legacy from Justice Scalia.
So that's going to require a little bit of unpacking, which I hope subsequent responses will contribute to, or you yourself. You made a reference to the decisions of the 60s and how that was, of course, a far cry from textualism. Do you want to just provide us with one really, really good example of that? I know you have many, but choose Griswold if you want. But
choose one that's entirely uncontroversial. Look, I don't know if I want to pick on any one, you know, a question, but you know, I mean, one question, for example, not picking a particular case, but you know, the Constitution is very specific in the due process clause, right, where it says that life, liberty, and property should not be taken except by due process of law. And one of those is life. So it seems that at least if you started looking from a textual perspective, there's at least an assumption that the death penalty is a constitutionally permissible punishment if it is done in a certain way. And I think today, if that case came up, there'd be a lot of grappling about the significance of that text and is it controlling, is it not? But there have been past periods where people have looked at that. Maybe that's not the best example in a way that didn't give primacy, I think, to the text, or at least a very important part. But this, again, these are the kind of sexy occasional cases. I think Michael's exactly right. 98% of what the court decides are not. They're ERISA cases, they're securities cases, there are all kinds of cases and statutory cases. And today the court, when it interprets it, has those cases, starts by working through the text in a way that I don't think was necessarily taken for granted as the correct beginning point in decades past.
And am I correct, Danielle, but before you go on, am I correct that the court has one of its rules or principles, self-imposed to be sure, is to try not to decide on the basis of constitutional issues, but on the statute itself? Is that, or is that misstating it totally? That they try not to bring it to ultimate constitutional questions?
Sorry.
Sorry.
Yeah, go ahead. I don't know who you're asking. Sorry, Sherry, go ahead.
Anyone.
They have a principle of constitutional avoidance, which means that they try to avoid a constitutional question. So if there's a statute, for example, that could be interpreted in one of two ways, and one of those interpretations will raise a particular constitutional question, might be unconstitutional, and the other way will not, then there's a sort of preference for selecting the interpretation that does not risk statute being invalid.
Okay, and Danielle, what were you going to say about textualism?
Yes, so I was just going to say that quote of Justice Kagan's, and she said it in a number of contexts, but often when she says it, it's in the context of honoring Justice Scalia's legacy. And I think that's worth pointing out because particularly in the statutory interpretation context where you're not dealing with these hot button constitutional issues, they were actually two justices who were very aligned in terms of how they approached interpretation, in terms of their writing style. And so the friendship of Justice Scalia and Justice Ginsburg is celebrated, but I actually think the relationship that developed in the later years between Justice Scalia and Justice Kagan is an example of how two justices that aren't necessarily associated with each other were often had more alignment than, let's say, Justice Scalia and Justice Alito, who is arguably more of a purposivist and less of a textualist.
Do you want to, even though it suggests the explanation, explain purposiveness? So
that's also what you saw more prior to to Justice Scalia bringing textualism to the court was a focus more on the purpose of a statute as opposed to the precise language, which perhaps lends itself sometimes to more outcome-oriented results.
Mm-hmm. Does anybody else would like to make a comment on interpretations? Yeah, go ahead.
I think in some ways, and the legacy here and the impact in terms of that sort of textualist approach or that textualist emphasis, it's far beyond the Supreme Court. It's far beyond particular judicial decisions. You think about how lawyers argue cases today, right? Lawyers in such a wide variety of contexts, look, you're going to make various arguments in support of your position, but if you have the text on your side, you're going to lead with that, right? And you'll have other arguments too that you're going to bring in, of course. You think you have legislative history, you have the purpose, you'll make those arguments too. But I think it's certainly a fair generalization that if you have the text, you're going to lead with the text. And the idea being that if you can convince the judge that the text is with you, that's a very powerful position to be in, and that's going to get, in terms of litigation strategy, sort of pride of place. Not the only argument you're going to make, to be sure, but the fact that I think these days most lawyers would lead with that just shows you kind of the impact it's had across the legal profession, really beyond just Supreme Court decisions. And
are there advantages to are there reasons why that is a preferable mode of interpretation? The reason why I'm asking that is I'm thinking, what way of interpreting the text, or what way of understanding the text? Are you understanding it in terms of, just to throw out two ideas that I'm thinking of, do you go looking for the common usage at that time? Do you go and look for the stated intent insofar as it's available of the people who inserted that into the constitutional text or statutory text for that matter? How do you, we all know from modern philosophy and linguists and postmodernism, so to speak, that text is something which is not so clear. So how do judges actually apply this notion of using the text, of referring to the text?
Well, I mean, it's a question that is answered differently whether you're talking about a statute of Congress or you're talking about the Constitution. I mean, typically,
let's turn to the Constitution.
When we talk about the Constitution, people either talk about the plain meaning of the words, although more likely people who tend to be textualists talk about the original meaning of the words. How were these words understood at the time of the founding? Whereas when we talk about statutes, I mean, usually this question doesn't come up. It's what is the plain meaning, the dictionary definition of the word? And usually most laws are, recent enough that there's not a debate as to what a word meant today versus what it meant in 1972.
Yes, anybody else want to comment on this?
I would just add, you asked the question, how do justices apply this methodology given, the difficulty sometimes of understanding text? And I think the answer, as you would expect, is with varying degrees of integrity at varying at different times. Each justice, I don't think there's a single justice, textualist, purposivist, originalist, it doesn't matter, who goes in saying like, I really just kind of go in every day and I just figure out what I want to have happen here. And then I just go and do that. And nor would they say that I figure that out and then I secretly try and dress up the conclusion that I reach in some kind of methodological approach that people will find more palatable. So I think textualism is a lot like, many other ways of interpreting the Constitution. It's a way of guiding answers, of thinking, beginning to think about a legal problem that you're presented with. And I think that, as with many other interpretive approaches, it has its limits for reasons like the one that you mentioned earlier.
Sherry, comment? Oops, no, you got to unmute yourself.
I think that Justice Kagan probably was being at least a little bit cynical in saying we're all textualists now. Like, that's a way of saying nobody's a textualist, right? And so, yes, of course we all look at the text and, you know, whether it's the Constitution or a statute, but we bring our priors to the job. And so we come out with somewhat predictable, and it's, you know, over time it's become more predictable rather than less so. And where, you know, you at any controversial case, you can predict how everybody's going to come out based on their views. And I mean, there's some reason to think that people who have executive branch experience and have kind of displayed their particular views in that within that scope are more likely to be reliably whatever it is they are. Like, to give you an example that's not at all politically sexy or whatever, the rules of evidence at some, I think they're, as statutes go, are fairly well constructed, and you can read them and know what they mean. You don't have to read them 8 times to figure out what, there aren't 70 subordinate clauses. I mean, it could use some further editing, but there were some stylistic edits made, and there were all of this sort of like, this does not change anything, you know, and it's sort of, we're just making it cleaner. And of course it made changes because people had made all sorts of assumptions. There was an exception to the rule that you can't introduce prior character evidence. There's an exception for defendants, you know, or people, I guess it said something like people accused of something. And so in civil cases, people are accused of things that are also crimes. And so it was interpreted to include that, and that was not what was thought to be. So even in the most kind of arcane parts of the law, it is really not necessarily possible. Like when we say, I'm going to do whatever the text tells me, it's very often not the case that the text tells you very much that's constraining. It gives you a kind of idea. So if it says, you know, if it says something about the accused, you know, you're not talking about, you know, whether you're allowed to pick up a quarter on Shabbos, but it's not going to really give you enough to decide, I think, in many, many cases.
You know, that reminds me, there's one last subject, but before I get to that, what you're saying, Sherry, reminds me of the following, and I'm going to just throw out this question. Do you know why, in the case where a member of the federal judiciary is thought it necessary to remove them, do you know why they do it through the impeachment process?
Is this a joke?
No.
Oh, okay. I was waiting for the punchline.
No punchline, no joke.
Okay, so they get impeached if they haven't been engaged for like bad behavior, I guess is the.
Yeah, but why the impeachment process? Why is that the means to remove them?
You mean as opposed to like a trial?
As opposed to another way of doing it, the congressional, not in a formal impeachment, but a congressional hearing, removal, simple majority vote.
Well, I think the answer has to, I mean, I actually haven't read about this, but I would assume that it's for the same reason that Supreme Court justices, that federal judges have life tenure and salary protection, right? Except for bad behavior, right? The idea is to insulate them from political pressure, right? If you have judges who have limited terms or have to come up for renewal, or have to come up, you know, have to be voted into office certainly, or whose salary can be diminished by the executive and legislative branches, the concern is that the federal judges will be, you know, will bend in cases where they're supposed to just apply the law straight up. They're going to be worried about their political futures and will try and, you know, curry favor through what they do with the law. So, right, the notion is that life tenure and salary protection gives judges independence and backbone. Right. And so a process that relied, I mean, the impeachment process is a political one, but it's a supermajoritarian one. Right. Ultimately. Well, impeachment is not, but removal is.
So the answer I was looking for was for somebody to say, but I think that's what you're really in effect saying, is because that's what the Constitution says, right?
Yes, the Constitution specifies that that judges can serve on good behavior, like it, and you know, it specifies they have life tenure and salary protection. Like the reasoning underlying, you know, why these provisions are there is, you know, rooted in. I mean, you know, read texts from the time that provide an explanation of why the various things were done.
So
you know, I just yammered on for a while with nothing that was in the text, certainly.
Right. But the reason I brought it up is because when the first federal judge came under suspicion and they wanted to remove him, the congressional majority, that was a Republican majority at that point, there was a debate. What does the Constitution say in terms of how do we remove him? And there's one clause in the Constitution which talks about the impeachment process and civil officers. And there's another part that talks about judges being removed except on good behavior. And they didn't know what that meant. They finally decided not to follow the British practice, but to actually adopt the impeachment practice. And the reason I'm bringing it up is here were these people who were around when the Constitution was written, and they didn't know what the text meant in the Constitution. They took the text and they made their choices. So it is a somewhat living process. Now, the last question. Almost everybody I know, when they talk about the court, talks about the importance of the court to protect minoritarian interests from majoritarian tyranny. And my final question is that actually what the court has done through most of its history? Or is the period from 1935 to about 1970 an exceptional period where the court actually made decisions, usually by very, very loose interpretations, that were not favoring the privileged interests of the country? I'm referring, of course, to a recent book, Supreme Injustice, and I wonder what you think of that argument, that the court is really a court that acts not to protect voiceless minorities, powerless minorities, but quite the opposite. So that's a controversial issue, which I think is a great one to end on. Who wants to take that up?
I can give it a shot.
Give it a shot.
I would say that it does both different times. I don't think the court consistently protects the powerless, but I also think that at times it does. There was one oral argument in a case, I think it was Fulton against Philadelphia this term, where there was I guess Philadelphia had kind of contracted with various agencies to select foster parents, basically to screen potential foster parents to decide whether they were, you know, suitable. And there was one like Catholic Charities that didn't want to screen any of the same-sex couples because they thought that that was wrong. And so Philadelphia said, okay, well, we have a sort of anti-discrimination approach to things, so you can continue to work with us till the end of the year, and then you're going to have to stop being part of our selection process because you discriminate. So the Catholic Charity brought a lawsuit, went up to the Supreme Court. And what they argued was that they have a free exercise of religion right under the First Amendment to maintain their contract, notwithstanding what they were doing. And it wasn't so much the issues of the case that struck me as relevant to your question, but the way in which Justice Alito sort of went back and forth with the advocates. And it was clear, you know, he's like, well, there are other agencies that will work with same-sex couples, so why do they need this one too? And it's, of course, if anyone made that argument about race, it would go nowhere. Well, there are other restaurants you could go to, so this one doesn't accept. I mean, and it sort of went back and forth, and then Justice Kavanaugh came in and said, well, you know, this is kind of extreme, making them, you know, screen the. And the sort of the sense I had was they are utterly identified with the powerful party here. And they have absolutely no sense of empathy for the party that just wants not to be discriminated against. And that isn't always true. And it, you know, but it was true in this particular exchange. It was very striking that they felt like, you know, Justice Alito said something like, this is, you know, a Catholic value. And the reason you're even bringing this case, I think it was Neil Katyal, he said to him, you're just bringing this case because you don't like it that Catholics, you know, do the Catholic thing or something like that. And it's this sense of kind of what I would call aggrieved entitlement by people who really shouldn't feel entitled or aggrieved.
I'll just chime in with a slightly different perspective, which it also going back to your original question, the premise was that it's universally agreed that the role of the Supreme Court should be to protect minorities.
Oh no, let me make sure I was clear. It's a widespread perception by people. I personally don't believe there's a should involved here, but
got it. Okay,
yeah,
so I don't mean to mischaracterize your question, but I just want to throw out kind of a different framework, which some of the justices clearly subscribe to, which is it can be potentially problematic to wade into certain debates about rights for particular groups that designate themselves as minorities or as persecuted, when there might not be some specific constitutional right enumerated to protect that group, or where another group of the country might actually perceive that group that has described itself as a minority is actually quite politically powerful. And the view there is some of these issues should be left to the political process. And perhaps the justices should not, for example, favor one group that sees itself as discriminated against over religious rights asserted by another group. So I think it is more complicated once we get past issues like race, which has its designated amendments to groups that through one lens could be perceived as discriminated minorities, through another could be perceived as having the political power to achieve certain results through the political.
Which ones are the designated race amendments? Which ones have the word race?
Well, I'm referring to the amendments passed, you know, after the Civil War to protect race.
Right, but they didn't specify race. I bring this up because Justice Scalia was constantly saying that race was right in there, right in the 14th Amendment, and actually it's not.
I would just jump in with, you know, thinking about Justice Ginsburg and her approach to fighting for gender equality, and how, you know, she definitely recognized she had to proceed incrementally and looked for cases where men were actually the victim of gender discrimination, because she thought justices and ultimately the court would be more ready to recognize the discrimination in that context and extend protection to another protected class when the argument was phrased from a perspective they understood. And I think it shows that the court can recognize new rights for minorities, or I guess gender isn't necessarily a minority, but a class that hasn't been afforded equal treatment, but that the court isn't always ready to do that. And sometimes it proceeds incrementally. And so I think there's not a yes or no answer to your question.
And I think it's not just about the court being ready to go incrementally. Sometimes it's taking the temperature of the country.
Of the country, yes. So I will honestly tell you, I could go for all day long talking about this and talking about these issues. I love it, but we have an audience out there which needs to go on and go to bed. I'm sure you need to go on. Mr. Rockland, I'm willing to stay on, but
you're welcome to stay on with everyone that would like to stay on and continue the conversation. It seems like we have still a very nice audience watching, and if there's more opportunity for everyone to join together, please feel free to continue on.
But feel no compunction, anyone, about leaving. I want to thank you all again. Please permit me to say this. You make us and me so proud that I teach in an institution that's produced such wonderful people, valuable servants of society like yourselves, who are also willing to come and spend an evening with us. Thanks again.
Thank you, Sherry. Thank you, Rebecca, Michael, Ben, Dan, Danielle, Gil. This has been just a true pleasure for all of us. And we are going to continue because I think Dr. Jucovy is very happy to stay on. I'm sure there are questions in the Q&A that maybe you even want to take and see for those who are able to stay on that you can respond to, because I have a feeling you have some very, very interested people, since this has been a fascinating conversation.
So I need to drop off, and I just, if I may, I want to say one last thing before I do, because Dr. Jucovy is mentioning how proud he is of us. And I guess I want to say, when I was clerking, the year that I was there, my parents came to visit, and I think the justice was actually away that day, you know, but like you could take them on a like behind the scenes tour, and we're actually in Justice Scalia's office, in his chambers, and he's got a portrait of George Washington, like a legit actual portrait of George Washington on the wall, and his desk is right there. And my mom looks at me and she says, "Gil, you are now even on the Nafis to Tsuris ratio." And I just felt like I must have been really bad if this is what it took for me just to break even. So when you tell me you feel proud of me in this particular context, it makes me think of that story. And I'm going to drop off now. I'm glad I got to participate. Thank you.
Thank you so much, Gil.
It's a great ending.
I'm going to jump off, but thank you, Dr. Jacoby and Kenny and everyone. Great seeing you.
I'm going to jump off as well. Thank you very much.
I think I need to.
I'm
as
gonna need to
well.
go as well.
Jucovy, stay on all night. Talk.
Yeah.
Very
Okay,
good.
thank you all so much.
Thanks.
Guys, this has been
Thank you,
really
audience.
wonderful.
Thank you so much.
Good night, all.
Good night, everyone, and good
Thanks for
night,
having us.
audience, and thank you all for staying on.